Hello, my name's Alex. I'm a member of the Political Education Committee in ATLDSA. This is going to be a presentation to introduce some topics in constitutional theory and left wing jurisprudence. But mostly, I'm going to be talking about the history of the Supreme Court and its interactions with left wing movements. So, the 14th Amendment is, I think, the best place to start because this is the introduction of the value of equality into the Constitution. We have things like equal representation in the Senate, but the 14th Amendment is a really radical turn in constitutional law where there's now a textual basis for making persons more equal in the supreme law of the US. In the 1880s, and especially the 1890s, the Supreme Court becomes a lot more conservative, even while a lot of European immigrants are raising the popularity of Marxist politics in the Midwest and in the Northeast. So, the lesson of the late 19th century and the very early 20th century, in my view, is that even if you have an outside strategy for social change, even if you think that courts are conservative institutions, you have to pay attention to them because otherwise they can get in your way. President Lincoln and President Grant were both fully dedicated to the cause of abolition. I mean, that's sometimes disputed, but they both had left wing views on the Dred Scott decision and stopping the Supreme Court from enacting the program of the slave power. But when it was time for President Lincoln and President Grant to appoint Supreme Court justices, they selected railroad attorneys because they wanted to shore up the Republican Party's fundraising relationship with the railroad power. So it didn't take long for those railroad attorneys to use those seats to beat back the Republican agenda. And the integration of black people into a multiracial democracy was kind of irrevocably stunted by that oversight. So the next thing I'm going to talk about is the legal realist movement. I said movement because I guess you could call it a movement, but sometimes it's called a moment. They call it the legal realist moment, the legal realist mood. The point is, there was a lot of opposition to the judiciary in the early 20th century because they sucked. Even in the lower courts, there was this mood among judges that the law was kind of a sovereign cell that needed to protect itself from the outside. So legislation would come before courts, even state courts, and judges would resist it. They were really determined to keep the law as it was. There was a belief that law was a science and that you could always determine the correct legal answer. And if the legislature wrote something that contradicted that correct legal doctrine, then judges not only could strike it down, but had a duty to get rid of it. The Lochner era is named after a case called Lochner v. New York, where the Supreme Court is telling the state of New York that it's not allowed to impose limits on how many hours children work per week. So the Lochner case doesn't have a huge direct effect on the laws of lots and lots of states in the way that Roe v. Wade did, for example. But Lochner is significant because the Supreme Court is really asserting itself as the legal foothold for the ruling class. There's legislators in the progressive era in states, in the US Senate, in the US House, governors who are trying to do something about the coarsening of the American economy, about the deaths of women and children and these awful working conditions. So legal realists come along to dispute the idea that judging really is a science. The legal realists argue that there are always enough cases and precedents that you can find the answer that you want and support it reasonably well using arranging cases in this or that way. And this raised a question that legal realists couldn't really bring themselves to answer comprehensively, which was, if they're not just applying the law, then what is actually motivating judges to decide cases in the way that they do? If there's always 2 or 3 or 10 correct answers, then why do they pick one outcome over the other? Because there's always 2 parties in a case that feel really strongly about something. The Warren Court sort of poured a little cold water on the legal realist movement just because the law was suddenly looking a lot better. There were major landmark decisions in the rights of women, the protections of criminal defendants, finally realizing the promise of the 15th Amendment. Black people are voting, students have religious and speech protections at school. It's the only point in American history where the Supreme Court has really done what people think of the Supreme Court as doing, which is protecting the rights of the individual and stopping barbaric electoral majorities in the states from being cruel to minorities. And then I want to talk for just a moment about critical legal studies. This is, I guess, a movement in legal scholarship in the 1970s and 1980s where legal realism had already critiqued the idea that precedent was a constraint on judges. Critical legal studies goes a step further and they say there's really no feasible way to have a rule of law in the way that lawyers think of that term, where even in theory, in an ideal judiciary, no formalistic framework can force judges to decide cases in a way that they don't want to. So maybe what actually constrains them is just they don't want people to say rude things to them at cocktail parties. You don't want to be the Supreme Court justice who voted to hear Trump's appeal of the 2020 election case. You don't want to be embarrassed. You don't want people to egg your house. But it's not the form of law that's causing them to slow their hand. Unlike legal realism, which sort of floundered by trying so hard to remain nonpartisan, critical legal studies was and is explicitly left wing. And their projects have really been focused on using the law as a tool for emancipation, liberation. So that's about as far as I wanted to go today. Hope this was helpful. Thank you.